Good morning, gentlemen. I just wanted to introduce myself first. I'm Brian Wasslew with the firm of Sherrod Coos in Toronto, Ontario, Canada. And to my right, I have Roger Hofer of the firm Newman Thompson, based in Edmonton, Alberta.
Morning.
Good morning. And James Kondopoulos with Roper Grail in Vancouver in beautiful British Columbia, Canada.
Right.
And I thought this morning we could take a few moments to discuss a topic that is, I think, probably safely said, whispered amongst some employer clients of ours. It's not a concept that's necessarily easily understood, but can be a very important one. That concept being the frustration of contract in the employment scenario or the employment contract context. So James, why don't you start us off with a high-level idea of what frustration means in employment?
Sure thing, Brian. And I'm glad you introduced the topic in that way. It is very much the holy grail of employment law, and to achieve it is a difficult thing to do from the employer or employer counsel perspective. But where achieved, does eliminate generally the need for termination pay, termination notice, subject to a narrow statutory exception, which we will talk about in a few minutes.
I'm familiar.
But the concept basically is one of work for pay, work in exchange for pay. And if the employee is simply incapable of delivering work, delivering the services for which he or she contracted, the idea is that the contract is frustrated at an end through no fault of the employee. And it's really something that was beyond the contemplation of the parties. The contract comes to an end. Again, no fault on the part of the employee. The contract has become impossible to perform, and the employer is relieved of its obligations under the contract, and the contract is terminable without pay.
So it's sort of like the bottom has fallen out.
Exactly, yes.
Well, so Roger, so how do we determine at what point the contract has become frustrated?
You've got to be in a position where the employee is not able to attend at work, has not attended at work either for some very lengthy time or for a very lengthy period of time, has not been able to attend at work with any kind of regularity. And you've got to be in a position where there is no realistic prospect that that situation will improve in the reasonably foreseeable future. The whole concept is overlaid by our human rights obligations, which include the very difficult issue of duty to accommodate. So the mere fact that the employee is unable to attend at work in his usual job won't get you there if, from a human rights perspective, you would be able to accommodate them in some alternative role.
Right. And I guess it's interesting because you just mentioned in itself sort of the attendance aspect of it. Now, I've assisted clients in the past where they might have purchased a company and then they're now learning about their workforce and will talk to me about employees who haven't been present in the workplace for years, and they're simply not familiar with the concept of frustration. And I think that's one of the examples that some of the management council usually go to, is the employee who's been absent for a very long period of time. Is there any magic number in terms of time or length of absence?
There is not, but you identified something that really points at the two different versions of frustration. One version is the employee who has suffered a permanent, serious disabling position that absolutely keeps them from being able to come into work in any capacity. So those people may be gone. In many employers, in a scenario where they've been through a short-term disability plan, they then go on to a long-term disability plan, and most long-term disability contracts have a 2-year period in which the employee will continue to get benefits while disabled from their own occupation. The phrase in the industry is the own-oc period. And after 2 years, they will continue to get long-term disability benefits if disabled from any occupation for which they're reasonably qualified. Certainly, I think, except in some very extreme cases where the nature of the disability is such that you know they will never be able to return to work, you've got to get at least through that 2-year period. before you're able to say that a contract with one of those people has been frustrated. And then you've got the other situation of people who are able to come to work sometimes, but just so sporadically or so little as compared to their colleagues that it's still creating a lot of difficulty in the workplace.
When I think, James, didn't you mention that you had a recent experience?
Yes, and I'll speak to that point quickly. The second type of absenteeism, non-culpable or innocent absenteeism, is probably the more difficult one for employers to manage. And what that typically looks like is employee is absent for a week, 2 weeks, maybe a month, comes back to work for a few days, and then is back off sick. The case you talk about, the recent arbitration award I was involved with, the employee had an absenteeism rate of approximately 45%. So 45% of the total time this employee was away from work.
Not necessarily smack. I mean, we've seen worse.
Absolutely.
And certainly I have too, but this was a case where 45% absenteeism rate, the evidence showed that that was 7 to 9 times the rate of his coworkers. The employer in that case was able to demonstrate on the evidence that this employee was simply not meeting the requirements of the job. And more importantly, that was working incredible hardship on the employer. It was a healthcare setting, and this fellow worked, ironically, in scheduling. He was responsible for arranging coverage for last-minute calls from fellow employees that they would not be coming into work. So needless to say, that caused all kinds of operational and business problems, and frankly, end of the day, had a severe impact on patient care because of the unpredictability. This went on over a period of a number of years. The absenteeism was attributable not only to medical reasons and various medical reasons, but to non-medical reasons too. There were stories from the griever about missing work because the skunk sprayed his dog, or his house burned, or his car was broken into. So we had an accumulation of multiple reasons for the absences over a very lengthy period of time. And the onus shifted to him, given that past record of non-attendance, to show he would be capable of attending regularly and reliably at work in the future. And he was unable to show that. He was unable to show the arbitrator that he could do that. And ultimately, his employment was terminated. We could term it frustration of contract. In the arbitral context, we call it innocent, non-culpable absenteeism.
I think that last point, James, is an interesting one. Although we are realistically talking about the concept of frustration, if you go back into the legal roots of that concept, it is frustration occurs in a situation that the parties really couldn't have anticipated. And particularly in a labor context, but again in an employment context, I tend not to use that word, because anytime you've got a short-term disability plan or a long-term disability plan, how can you say that you didn't anticipate that the employee could be gone for long periods of time? So I like James, go with the concept of innocent absenteeism or non-culpable absenteeism when it gets to a point that it's created undue hardship for the employer, and it gets to the point where either you can demonstrate through medical evidence or the history is so extreme that there really is no reasonable prospect that the employee can point at that it's going to get better. You've got a good case for severing the relationship. And in our jurisdiction, Alberta, and in most of the jurisdictions, as I understand it, except for yours, that means you can sever them without even giving them any compensation under the Employment Standards Statute.
And if you'll permit me, I'll take a moment to address that issue, because as we've said, the frustration of the contract or innocent absenteeism, but the gist of it being that fundamental trade has broken down due to unforeseen events, and the basic value equation has disappeared, so the obligations disappear. In Ontario, the concepts are not any different across, as similar to the other common law provinces. The justification and the rationalization is the same. Nevertheless, apart from that common law obligation of just pure contract and what an employer owes an employee, we do have the Employment Standards Statute that also sets a basic floor for certain entitlements. And the wisdom of that statute has decided that in the frustration circumstance where an employee is not going to be able to return to work and the bottom has fallen out of that arrangement, the employer still is required to provide that employee with the basic statutory amounts under the Employment Standards Act of Ontario for notice and severance, which run in the neighborhood of a week per year of service for notice up to 8 weeks, and severance is an additional week per year of service up to 26 weeks. So they will not owe the employee the larger common law amount that a judge might award, but they are required to provide the base employment standards amount to that employee, regardless.
I'm just going to jump in there and say how surprised I've always been by that exception under the Ontario Employment Standards Law. And the reason for my surprise is this. If the contract is frustrated, if it's become impossible to perform, surely everybody's relieved of their obligations under the contract. But what I understand is it's a statutory override, and the ordinary common law principles, the judge-made principles, don't apply, and you have the statute.
I think that's probably the best way to sum it up. It's a version of a statutory override. Yeah.
Now, there's one other point I wanted to make in terms of an override. Some contracts have deemed termination provisions. And we typically see that in executive employment agreements. And it might say something like, if employee has been absent from work for a period of 6 months, an uninterrupted period of 6 months, he or she will be terminated. And effectively, the contract is frustrated. Now, that language is useful if an employer is trying to demonstrate a frustration of contract. But I do want to underscore that it's not determinative. Ultimately, a court, a human rights panel, an arbitration board will consider all of the surrounding circumstances and decide whether or not frustration has actually occurred. We also see those deemed termination provisions sometimes in collective agreements, of course. And the Supreme Court of Canada has indicated very clearly that those deemed termination provisions demonstrate the intention of the parties to the collective agreement and should be given some weight, but ultimately they're not determinative.
I think that's a good point, James, and it goes back to the principle that you can't say there is a particular magic time period, because this is all driven by the human rights overlay and duty to accommodate. You still have to assess every case individually.
Yes.
And as in any case involving human rights and the duty to accommodate, it's very helpful if the employer is able to demonstrate the steps that they have taken, the hardships they have faced in trying to accommodate the employee, and to give them every opportunity to show that they're capable of attending work on a regular basis so the employer gets their side of the bargain.
Right, and one of the ways that I've attempted to try to explain what is not a straightforward area is to use the example that in theory, an employee, you could reach that point of no reasonable prospect of returning to work almost immediately if there's a very unfortunate circumstance where we have a significant limitation and there really is no accommodation apparent. So timing really is irrelevant in some circumstances.
And one point I want to add, Roger, Brian, is the onus ultimately of establishing the frustration of contract and the fact that the point of undue hardship has been reached lies on the employer. It's the employer's case to make. And some of the factors which are useful to employers include position occupied by the employee. Is it a key position or is it a run-of-the-mill, shop floor kind of position? Length of service of the employee is useful to look at. Are you dealing with a 25-year employee or a 3-month employee? Just an example. We've talked a bit about deemed termination provisions, and I've alluded to impact on the employer's operation and business. Again, that healthcare case I talked about, the one I was involved in. So those are the sorts of factors we look at in deciding whether or not a frustration of contract has occurred or the point of undue hardship in the human rights context has been reached.
You know, I think that we've done a fairly good job of addressing a complicated issue at the top and drilling down on a few particular items. Unless you gentlemen have anything in particular to add, I think we've done a good service, and certainly trust that if anyone is faced with these difficult issues, they might reach out for some guidance.
Thank you.
Thank you very much.
Thank you, Brian. Thanks, Roger.